Hello, this is Attorney Brian Pendergraph with Planlord, and this is the I guess a video presentation where I did a quick checklist to go off my latest blog post, how I successfully evict tenants 9 times out of 10, and I thought I'd just make a quick checklist that you guys can download, and hopefully this will be helpful in running your landlord business to because if you run your business better, it'll make it a whole lot easier for me to evict tenants. Whether or not I can successfully evict the tenant actually has more to do with you than what it has to do with me, because it mostly depends on the landlord's conduct and how they run their business. Which brings me to point number one. The case is actually won or lost before I even step into the courtroom. So if you run your landlord business right, or you run it the correct way, then my job will be very easy. So keep that in mind. And now point number two: use county specific lease agreements. Well, you definitely want to have written lease agreements. There's plenty of state specific lease agreements floating around, but your county or even your city, where applicable, they may have their own unique landlord tenant law. So you should have a lease agreement that references those or incorporates that. Number three, you need to have a rental history ledger that is kept in the ordinary course of business, especially if you hope to recover money for failure to pay rent. Otherwise, there's no proof that the tenant actually owes you money. Um, this is because a lot of landlords want to use bank statements or things of that nature in order to show that the paper trail, or that the tenant has missed a payment, but that's not sufficient. You need a rental history ledger. Um, Number four, you need a landlord license if it is required. Otherwise, your case will be dismissed. There's a good chance, I would say most landlords are probably required to have licenses. There are exceptions, but if you're required to have one, make sure that you have it. Um, Number five, we need a proof of proper notice if the cause of action requires it. For example, a tenant holding over case, or a sort of breach of lease case. Sometimes a notice is required in order to prepare, in order to win the case. So you have to make sure you do a proper notice and have proof of it. Number six, proof landlord provided the tenant with good service. Now, by good service, I don't mean he served the tenant the notice. I literally mean like good service, like the landlord took care of issues going on with the house. Tenants like to claim that landlords provided bad service in order to justify rent escrow claims and other tenant defenses and non-payment of rent. So if you have proof that you provided the tenant with good service, then that is a good thing, such as let's say maintenance records. Or texts or emails or communications that you are a responsive landlord, and when there's issues, you fix them. Number seven, whenever I go to court, I always take a copy of the relevant laws with me. I made the mistake of thinking judges just knew all the laws and they applied them, but they know a lot, but sometimes they don't know it. So I actually had one case where the judge and I disagreed on the notice requirement. I was right, and I, quoted the law correctly, but he didn't listen to me. He didn't believe me. So he ended up postponing the case, and I was and I had to go back the next week. I brought the law with me, and everything was okay. So since then, whenever I go to evict tenants, I always take a copy of the law with me, because I do not take for granted that the judges just know it and that they are going to apply it. And then number eight is to this again, that's number seven, number eight. Both have more to do with me than you, but or hey, maybe you don't have an attorney. That said, you have to choose the right cause of action, and that is to pick the right complaint for the job. So there's plenty of ways to evict people. In Maryland, we have three. Your jurisdiction may be, well, three for tenants in particular. We have three for tenants, one for non-tenants, but three for tenants. Those are failure to pay rent, tenant holding over, and breach of lease. At least if so you're in Maryland, you have to pick the right one based on the situation. Or wherever you're at, whatever your jurisdiction's causes of actions are, make sure you pick the right one, and yeah, you can evict your tenant. All right, cool. So this is the Yeah, so you can download this by just clicking the link in the description. And thanks for watching. It's Brian Pendergraph. Don't be a landlord, be a planlord.